Again, thank you very much, Aoife. I think we've been very well served by the three experts this morning who've laid out their case. All right, we've 10 minutes left for discussion before coffee. Yeah.
Hiya, Fiona Wheeldon.
Fiona, sorry.
Just the Covenant says that states should have respect for the liberty of parents to choose for their children's schools to ensure the religious and moral education of their children in conformity with their own convictions. And I'm just wondering how religion is dealt with in other countries in relation to it as a cultural right. And has there been any of the assessments of Ireland, have they referred to religion and how we deal with religion in our cultural rights? Thanks.
Thanks, Fiona.
I think we might share the response to this question. It raises complicated issues because there's also a separate provision of the Constitution dealing with religion. But
into the mic.
Sorry, Tom, and sorry, audience. Article 42, which refers to this right of the parents to provide for the education, actually explicitly says to provide according to their means for the religious and moral, intellectual, physical, and social education of their children. And also in Article 42.4, after the provision that I referred to, it says that it shall endeavour to supplement and give reasonable aid to private and corporate educational initiative, and when the public good requires it, provide other educational facilities or institutions with due regard for the rights of the parents, in particular in the matter of religious and moral formation. So there's some, in our Constitution itself, there's language which is echoed in the Covenant, in fact, but of course the system that's on the ground raises difficult issues, as we saw in the recent Louise O'Keeffe case, because Ireland has historically a very distinctive form of education, which primarily involves the state funding, but not actually running the schools, which have traditionally been operated by various organs of the Catholic Church, and there's been a limited array of other options. But there is protection for the aspect of the right you refer to in the text of the Constitution as it currently stands. And I think in terms of the international dimension.
I mean, I think as well, you know, when you look at that particular right, if you look at, say, what we already have in terms of the European Convention of Human Rights Act, 2003, sorry, 2003, you're dealing with, you know, there is a certain level of protection. I think that if you were talking about compliance with that obligation, there are already mechanisms by which that can be given effect to, whether domestically or internationally, that would mean that it's perhaps one of the obligations that it isn't as pressing to address immediately if you were thinking about adding to what we have in the Constitution.
Thank you. Catherine, over here, please.
Yeah, I've just a couple of questions. First, you referenced Colombia on a couple of occasions, and I'm just wondering, is that a recent addition to their constitution? And did it change? Did it have the effect of change? If it was, did it have the effect of changing the culture, the political culture? And I'm looking at, for example, the city of Medellin, where you've seen you had Pablo Escobar on one side, and it was awful. And then you're looking at the rebuilding of the city, which is done with an entirely different culture of including people. You know, I'm just wondering, was there a dynamic there that changed the political culture? And the second thing is, are we asking ourselves to include this in the Constitution because our Parliament is ineffective, in that the executive have so much power and the Parliament has so little power? Would changing that balance really, you talked about Article 45, for example, as being a kind of a direction on the Parliament, but it's little attention is little used in the context of debate. Part of the reason for that is you can't, if you're a member of the opposition and you see something that is a flawed piece of legislation that doesn't vindicate, say, people's right to shelter, you can't change the legislation if it's going to be a charge on the state, because it'll be rejected and it won't even be subject to the debate. are we trying to do something in the Constitution that we really should be doing in terms of in terms of the balance of power in the Parliament, as opposed to explicitly putting rights into the Constitution?
Okay, thanks, Catherine. We'll take Susan, and then we'll go to the panel for, and then Francis. So Susan first, and then Francis, and then we'll go to the panel for a response.
If you start.
Mike.
Thanks, Chair. Susan O'Keefe. I just wanted to find out if, given that you've made it clear that the 1937 Constitution was, if you like, a basic one, and that since then we've seen lots of changes across the world, can you show measurable impact of where, having included these rights, you could say, well, specifically, look, in that country, when they did that, this is what happened? Because in a way, obviously, this is very difficult territory, and it's quite technical, and in order to grasp it, perhaps, examples of how other countries who've made that progress, who've changed, you could say, well, yes, there was an impact. It changed it in this way, either on the economic front, the cultural front, or the social front, or indeed it made things worse in a way, because it is quite difficult to grasp exactly how we would change it, because of course it does depend then on the model that's adopted, and indeed who chooses the model. Who is the arbiter of the model that would be put in place?
Okay, thank you. And then Francis, will be the final question in this session.
Thank you. Thank you for your presentations. I wanted to ask you about other countries, Professor Nolan, and how they have incorporated the rights. I mean, you talked at times about sort of priority of rights. How, what rights, and what is the process of the identification of which rights would go in and could be acted on? What's the experience around that? And potentially, what could it be in terms of identifying priority, or is it all done on the, if you like, the same basis across the rights?
Okay, we'll go across the panel. Maybe Aoife first.
Yeah, sure. I'm going to take the last question first, and I'm going to give a fairly, again, a general answer. I mean, the approaches have varied significantly across different countries. I mean, in some places you've had very high levels of consultation around constitutional protection, including economic, social and cultural rights. In others, it's been kind of a closed-door exercise amongst a very, very narrow group of people. So it's very much the same as you'd see with constitutional processes generally. Something that's had a huge influence, though, is international human rights law. Because, for instance, if a state is considering whether to give effect to ESCR, it cannot help but look at what it signed up to there, and that you'll see that frequently that's had a huge impact in terms of the rights that are in there. What you see, one of the shifts you do see, however, is, for instance, if you look at, say, the older constitutions, and a lot of the European constitutions are older, Western European constitutions, you'll see a focus on property rights, you'll see for instance, you might see reference to education. You're much less likely to see references, for instance, historically, maybe to the highest attainable standard of health, and frequently there would not have been quite the same level of social security rights that we might see now, though that would depend. Whereas now, when people go into identifying what economic, social and cultural rights would be, almost inevitably, they look at their own experience, they look at other countries, but they also look at kind of the key standard, which is the International Covenant. Does that help a little bit? Yeah. And it does explain why there's, to some degree, a certain uniformity in terms of what you tend to see across the board. There has been a big move post-1990, and those new constitutions have made huge use of international human rights standards. With the older constitutions, it's often been about reworking existing standards. Okay? Do you want me to take the other questions too? Yeah, I do. Yeah. So
from the range of questions.
ESCR litigation. I can give you a very good example, right? So it doesn't. There are times when economic, social, and cultural rights have very limited impact domestically. You can have situations where courts apply them in such a way that they end up actually causing more harm than good. There was a lot of criticism about, after the crisis in Latin America, in crises in the 1990s, that you saw the courts using constitutions to protect property rights, including the right to housing of mortgage holders, but weren't prepared to look at the situation of desperately poor people, right? That's since been addressed, but that's an example of just because you have them in there doesn't mean there's going to be a magical panacea to all sorts of problems. In South Africa, you have a model, and again, I'm not idealising what's happened there. There's been good examples and bad examples, predominantly good. But there's a very famous case called the Treatment Action Campaign case, where you had a situation during the Mbeki AIDS denialist era era, where you had a situation where antiretrovirals for women in public hospitals, I think 26% of whom were HIV positive, access to these antiretrovirals to mothers who were pregnant and during labour, which is when I think 50% of children acquire HIV through the exchange of bodily fluids and blood, etc. And the access to these antiretrovirals was limited to 10% of public hospitals on the basis that they were testing sites. And there was a case brought ultimately to the Constitutional Court arguing that this was unreasonable, that the state wasn't taking reasonable measures to progressively realise economic, social and cultural rights within the maximum of the resources available to it. And what happened was that ultimately you saw antiretrovirals being provided at all hospitals. So it had a huge impact for an extremely needy group of women. Again, looking at South Africa, say, if you think about apartheid and the mass displacement, right, and again, this is a specific national context, but that's fine. We'll be in our own national context if that's what's decided to be done. The protection against forced evictions and the right to adequate housing has played an enormous role in dealing with, say, forced displacement, shaping government homelessness policies, dealing with, say, city beautification campaigns that try to move out informal traders. They've had a very important role there and in shaping legislation in turn. So you do see very significant impacts. Final thing very quickly about Colombia. I mean, I think what you saw in Colombia was, and there's a huge amount written about the fact that the court for periods was criticised very heavily for being very disconnected from the needs of poor people and focusing on, say, the middle class and protecting those who had power and resources. But then you also saw economic, social and cultural rights litigation being used by those pushing for social change and actually serving as a very useful tool in terms of, if you had a court order, if you had a court action, serving as an impetus for government action as well. So you did see ESCR serving as kind of a site of contestation, a site of, pushing for social change. So that was very important. But it certainly wasn't just rights by themselves that resulted in that. It was a much broader context.
Just two of the issues. Susan's point about who chooses the model. Well, obviously, under our constitution, it will ultimately be the people who would choose the model, obviously on guidance provided by the government proposing a particular amendment to the constitution, which would then have to be approved by the constitution. But ultimately, it would be the people who'd have to say yes or no to a particular model of economic, social and cultural rights. The second issue is Catherine's very interesting question about whether if we reformed our parliament and informed the procedures and so on, the powers of Parliament, would we have any need for these economic, social and cultural rights? And I think that touches on a very, very important aspect of the debate. Certainly if Parliament had, a stronger role within our constitutional system, you might see their primary role of the Parliament in giving effect to these rights through legislation and so on, improve and take on a stronger presence within our constitutional systems. But I don't think that alone would be enough in light of our international and European obligations and so on. And if we're to take these rights seriously, we still have to face that difficult question about whether we want to actually enshrine them at the constitutional level. So I think that they're related questions, but they're kind of distinct issues, and the two can go along in parallel without there being any great tension between the two.
And very, very briefly, and somewhat linked with the same question about the Parliament and effectiveness, for certain socioeconomic rights that I can think of, local authorities, for example, adopting certain plans or certain strategies to move out certain groups, that is something that's concerning. And then within Parliament, you will always have those individuals who are not numerically significant in order to influence Parliament, and whose voices can certainly be lessened. Now, I don't think any of us are suggesting that courts are the only response. It is politics, it is government that will, in the main, be responsible for consulting on and deciding the level of protection in a democratic manner that individuals have as regards to socioeconomic rights. But whether constitutions can act as a very important baseline to say that as a society nobody will go below certain standard of living, then that could still be exceptionally useful. And I do appreciate the point that whether the whip system, I mean, the best means of dealing with the whip system is if people actually said, "Oh, I will vote how I feel," rather than allegiance to some broader political concept or, well, rather broader political party. So.
Okay, thank you very much. I think it's been I want to thank Aoife, David and Liam for giving a great base, I think, for our deliberations, which will start at half past 11 after your coffee. So thank you very much indeed.